Welcome to Ground Rules, employment law over your coffee break. My name is Pam Howland, and I'm here today with Jennifer Walrath and Doug Plass. We are attorneys at Idaho Employment Lawyers, and we're talking today about a topic that I think is gaining momentum out there. We've definitely run across a handful of situations involving this question over the past year, and that question is working a second job a terminable offense? Can you get fired if you work a second job? And really, the context that we're focusing on today is the one that we see this come up in most frequently, which is when someone's working from home, they've got a virtual arrangement, a remote arrangement, they maybe start to suddenly experience productivity problems or performance issues, or people need to reach them and suddenly they can't be found. And someone starts asking the question, I wonder if that employee has another job. That is when this comes up. It's somewhat of a fascinating issue, an evolving issue, and I think we're going to have fun today talking about what that means for employers. And when I say we're going to have fun, I mean we're going to talk about really exciting stuff like handbook policies, because that is one of our favorite things to talk about. Oh, you might be thinking that those are boring, but really they're so important that I feel like in every podcast, we're coming back to the issue of the importance of having good handbook policies. You need your handbook. It serves a very legitimate, important purpose for compliance reasons. You need to update it every year. And say you had something like this come up and you were worried you didn't have the right policies in place, what should you do? You should update your handbook, right? Like that's another reason to update is if you have a situation and you don't have the right policies and it creates chaos in your workplace, then update your handbook. That's a pretty easy fix. So, what do I mean by the need to have good policies when this issue comes up? Well, the first thing that came to my mind is that in our standard handbook, we have a conflict of interest policy. And that policy addresses when employees can have second jobs. And I know our handbook policy has language saying something like, if you want to work a second job and it's not a job that would compete with this one, we will likely allow it, but you need to disclose it to us. We need to have the conversation. And we want to make it clear that this is that your job with us is the priority. And if your performance starts to suffer, we may well say that you can't work that second job. So, surprisingly, I think for some employers, that policy comes in very handy. And in a situation like this one, where someone's working remotely and you think maybe they've got a second job, that would certainly be a good policy to have a conversation about. Another policy you might be thinking about, and hopefully after COVID, if you found yourself working remotely and you had employees who were transitioning from in-office jobs to virtual positions, hopefully you've got a remote work policy in there. And that may well address this situation. And it may have language in there that says something to the effect of, if you're working remotely, we expect that you're working during our regular business hours. We expect that if you're working remotely, your performance objectives will be met. If you're working remotely, we also expect that if we need to find you, that you're available. That's the big one. So those things can be handy too. And there's a lot of other reasons for a remote work policy, right? This is just one of many, but if you have employees working remotely, you should definitely make sure you've got a good policy in place. So, a remote work policy, a conflict of interest policy, and then another is a telecommuting agreement. I've seen employers who have employees working remotely who actually have those employees sign a specific agreement tailored to their job that lays out the expectations, and it might have some of that same language we've just talked about here. If you have those things, you're going to have a much better time handling a problem that might arise if you have an employee working at home and you think they're working a second job. Last thing I'm going to say before I pass the baton on to Jen or Doug to tackle some other issues related to this is think about your job descriptions too. Job descriptions, kind of like handbooks. They're not super exciting, but they serve such an important role from a compliance perspective. And if you've ever heard us talk about ADA, which we talk about, you absolutely need job descriptions because otherwise you're somewhat dead in the water when it comes to doing an accommodation analysis. Separate issue, but for purposes of someone working remotely, you might have the hours that they're expected to be working. You might clarify it's full time. You might say things like, you may be able to work at home so long as you're meeting your performance objectives. But again, you need to be somewhere where we can reach you if you need to be contacted by us. So, those are a few ideas on things you should be thinking about that you can put into place now that might help you resolve an issue if you think someone's working a second job.
And to add and pick that up, policies are really important. And one way that they're really important is because they provide a roadmap of expectations for the employee. So if your policies say, we need you to be available from 9 a.m. to 5 p.m. every day, the employee knows, gosh, if I'm going to do something else, I better not schedule it during those hours. So we will hammer that again and again and again on this podcast. Have good policies in place and follow them. But what should you do if you have this idea that there might be a second job involved, and you think that the performance is being affected by it? Well, the first thing you should do is document it. Over and over again, you need to document what is going on with your employees. And then, really what you should do is discuss it with your employees. Look, we've noticed your performance has fallen off. What's going on here? Is there something getting in the way? Is this remote work arrangement not working the way it's supposed to be working? Engage in a dialogue, figure out what is going on. For some positions, working a second job might not be an issue, but we're talking about the situations where it looks like it probably is. Your employee is not performing the way that you would expect them to be performing. You're going to want to think about, how could the second job be interfering? Is this a salaried exempt position? Is this a position where you need the employee to maybe be available sometime outside of normal work hours? Are there attendance problems? So have you had the situation where you try to get a hold of the employee in the afternoon and they don't get back to you till the next morning? What's going on? Have a conversation, figure out what's going on, have a conversation about them. And if an employee has disclosed that they have this other job, or they want to get this other job, you need to talk about how that's going to work, right? How we're going to handle when conflicts arise between the two things. How are you going to be assured that your job, your business remains the priority of that employee? So, and if you find out that they're probably working a second job, but they're not telling you about it, you may have to perform some sort of investigation. That would include interviewing that employee, possibly interviewing their coworkers, possibly going beyond the workplace to figure out exactly what's going on. Do you have some time tracking tools you might want to use? In that case, is the employee like logging in when they get into their computer and logging out? Are they using some sort of a spoof thing to jiggle their mouse or whatever employees do these days to try to make sure that it looks like they're working? Figure out what the basis is for why you think they might be working a second job, and figure out if you have an honesty issue here, right? If you think that the employee is not being straight with you, that in itself might be a reason to take some action, even if there isn't another job involved.
Yeah, I forgot to say at the beginning, I was poking around before we got on the podcast and I found a website for Resume Builder that was talking about statistics of how many employees are working more than one job when they're working remotely. And the statistic was like 80% of employees working remote jobs may have more than one job, and 37% are working two full-time jobs.
Well, if you
So
heard that, that was the sound of my jaw dropping.
I know.
They're not lawyers.
They're not lawyers. That's right. Yeah. And then you should check that out. Again, it's at Resume Builder and it's talking about statistics on when employees are working more than one job. So there was this scenario of an employee working remotely, working more than one job, working more than one full-time job. And then it said, so how many hours are they actually working if they're working more than one full-time job? And it said like 40. So you think about that, the employer's probably not getting the benefit of the bargain there, right?
Yeah, so this is, you mentioned job descriptions before. Gosh, look at your job description. If you have a job description that can get done in 2.5 hours a day, maybe it's not a full-time position. Maybe it looks like something else.
Yep. Yeah. So investigations, like Doug said, we love investigations really, because if you're a lawyer like we are and someone comes to you and says, I had a performance concern, I talked to the employee, I still didn't feel like I had the answers, so I conducted this internal investigation and here's my findings. That gives your attorney and you a lot to work with, right? Just the fact that you went through some kind of process, gathered info, hopefully documented it. Depending on what your investigation concludes, under Doug's scenario, if you've had the conversation with the employee, if the employee says they're not working a second job, but your investigation concludes they are, and if you have a good handbook, boy, you've probably got someone lying right there, and that's probably a code of conduct violation. And then there's likely the conflict of interest and hours violations too. So that's something to be thinking about. And Jen's going to talk a little bit about competition and confidentiality concerns. We have, I think I've mentioned before, a lot of litigation on that. We get a lot of calls on that. Competition and confidentiality are a big deal. And as an employer, you should always be thinking about that in different contexts.
Yes, and in this context, we've talked a lot about the impact that someone having a second job can have on their performance, but it certainly is a situation that can raise concerns for the employer about the security of their information and whether or not the employee is doing something that could potentially damage their business. So that's one reason why having a policy is really important, because the policy, if the person's following it, means they're going to disclose to you that they had this other job and provide you information about it so that you can evaluate whether or not it presents those kinds of concerns for you as an employer. So, are they working in the same industry? Are they doing a similar job but in a different industry that doesn't, concern you from a competition standpoint? And even if you don't have a non-competition agreement, while an employee is working for you, typically they do still owe certain duties under state law, duties of loyalty, and, are expected often under policy as well to be working for the benefit of the employer and not for the benefit of someone else. Also, even if you're not necessarily worried about competition, you might still want to make sure that your information that you are giving that employee access to in order to perform work for you is staying confidential within your business or your organization. There are various ways to do this. Of course, one, like I say, is to have your policy about conflict of interest so that you can remind the employee of their confidentiality obligations. But then on top of that, you're going to want to actually have confidentiality obligations in place in your workplace. We always have in our handbook a confidentiality policy that applies to all employees. Sometimes there's tailoring depending on the nature of your business, but generally speaking, there's always going to be something in terms of information within your business or organization that you consider confidential and want to instruct your employees not to be disclosing or using outside of their work. You also can have confidentiality agreements, non-disclosure agreements that employees sign and enter into separately, where they actually agree, right, to keep the information confidential and not to share it. So I think those are all very good things to do in your business generally. But also, if you do find out that you have an employee moonlighting essentially and working a second job and you have those concerns, then your policies and your agreements also become tools, right? To talk to that employee, to sit down with them, to remind them of their obligations, ensure that they haven't violated them, or if they have, to take whatever action is appropriate to address that violation. And the other thing I might mention too in that regard is more practical. And that is just making sure that you have good technology related, I'll call it protocols, right? Like if you expect your employees to use cellular phones, best practice is to give them a work phone so that they don't have company information on their personal phone. Giving your employees work computers, ensuring that there's some sort of password protection or other safeguards in place so that that information, has limited access. If you have especially sensitive information, you might even have protocols that say employees can't take their computers home. Things like that. It really depends on the level of protection that you need for your information, but to have thought about those things in advance and have those in place, whether it's policies in your handbook or just protocols that you follow when you're onboarding employees and have them working for you. And I think the last thing I'll say is, kind of on the flip side, I suppose, if someone is working somewhere where you don't have any concerns that it's a competing job, you aren't worried about their divided loyalties, and you aren't worried about them, not devoting enough time and effort and energy, maybe it's okay that they have that second job. But you still would want to make sure just to remind them about, please keep the information confidential. Don't be talking about our work at the other job, things like that. To the extent that you're concerned, it's still a valid conversation to have with those employees.
Yeah, another consideration for that scenario is what if you have an employee, you find out they're working a second job and they're not competing? I think one of the questions is just, what is the second job? Are there enough hours in the day? And are they going to sap all their energy devoted to this other job instead of to your job? Like, how many hours in the day can somebody be on? That's one more thing to think through.
It is, but there may be some people where you decide, it's not really that big of a deal. Look, if somebody's going out and getting a second job, what that shows to me is they have hustle, right? And as long as you're getting enough hustle directed toward your organization, maybe that's the kind of person that you do want to keep employed. It's really going to depend on the specifics of your business and what your job requires. And really what the other job they have is, right? If they have a job that requires a lot of mental energy during the day and they're going out and doing some physical thing for 3 or 4 hours in the evening, I mean, great. So, but one thing that Jennifer mentioned I wanted to pick up on was this idea of employer issued devices. So if you're an employer and you've issued the computer or the cell phone, then you have the ability to access it, right? So that gives you the ability to figure out whether or not that information is going out or other information is coming in. And on the back end, kind of look and see what's happening. If you're letting your employees use their own personal devices, it's real hard for you to get in there and look at it. And it's certainly possible that your information could be commingled with somebody else's information. So that's really important, I think.
And I guess at the end of the day, too, what we're really encouraging here is you want to be aware if someone's working a second job. And if they have told you they are, or you think they are, probably a good first step is to sit down and just have a candid conversation with that employee. And I was thinking about Doug's comment about hustle. Another reason someone might be working a second job is they say, look, I'm just not making enough money here to make ends meet. I need a second job. Maybe you can have a conversation about their compensation, and there's something that can be done to say, okay, we can make some changes here so you don't have to work a second job, or, that looks a little bit different. So perhaps there's some other reason out there, some other solution that is actually a win-win for everybody, but you won't know unless you actually just sit down and have the conversation.
Yep. And I was going to piggyback on what Doug said about employer-issued devices. We've had a handful of cases that have involved employers who let their employees use their personal cell phones, and it really is very difficult if you're an employer to figure out whether or not your contacts got shared, whether or not they got used. And if you end up in litigation over that, letting employees use personal cell phones to conduct company business creates so much risk for your organization. We hear all the time employers say, oh, it's too much of a hassle for my employees to carry around 2 devices, or, oh, it's too expensive. We don't want to do company issued cell phones, but if a problem comes up, you will be very glad you did. Very hard to say that you viewed and treated info as being confidential, proprietary, or trade secret if you're letting your employees download it and use it on their personal devices. So a lot of reasons for that. And in fact, we have an episode coming up in a few weeks that talks about confidentiality, trade secrets. We like talking about that stuff. I anticipate we'll have numerous episodes on that because the law really is changing and evolving in that area in a lot of fascinating ways. So stay tuned for that. And otherwise, that's it for today on Ground Rules. We hope you enjoyed this episode. We'd remind you to check out our book, our Law for Leaders book. We don't have a chapter on this exact issue, but we do have other chapters that relate to many of the things we've talked about, including the confidentiality, non-compete, non-solicitation piece. There's chapters there on, basic performance management, why you need to document. There's chapters on investigations. There's a lot of the foundational issues that we cover both in our Law for Leaders book and in our Law for Leaders virtual and live training program. Training is so, so important. And if you're an employer, you better make sure your supervisors are getting trained to stay out of court. So that's it for today. Thanks for joining us on Ground Rules. Ground Rules hosts and guests are not providing legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction.